Right, there we go. That was a bit more painful than I thought it would be. I'm talking to you this afternoon about COVID-19 policy and procedure, both in terms of what the Home Office are doing and also in terms of what the tribunal system is doing in light of the difficulties that we're currently facing. I'm going to start off with Home Office policy and procedure and move on to the tribunal, both first tier and upper tribunal, covering both statutory appeals and judicial reviews. I'm starting this, however, with a little bit of a health warning. Things change and they change rapidly. There's been a change today in respect of no recourse to public funds, which we'll talk about in a little while. So the notes are low there, pretty much up to date as of, well, yesterday they're up to date. They are rapid changes and have in fact been amended since I did this talk last week because of changes. So be aware, there are changes all the time, and the UKVI website will keep you up to date with those changes. The overriding principle that the Home Office appear to have in respect of their approach to COVID-19 is that it is said the Home Office and its ministers are very clear that no one should have a negative outcome through the immigration system due to a circumstance that was beyond their control. And that is apparently the starting point for everything that the Home Office are looking to do. As we go through the talk this afternoon, you'll see that there are a few areas where that perhaps isn't being reflected entirely in their policy, but it's worth bearing in mind that that is the overriding principle that they are supposed to be applying when dealing with situations that have arisen in light of COVID-19. I've just popped the contact email address and telephone number for the help desk should you need to contact them directly on that first screen. So moving on to the first issue, and that's visa extensions. On the 17th of February 2020, Chinese citizens in the UK were told that they would get automatic extensions up to the 31st of March 2020 if they had a visa with an expiry date between the 24th of January and the 30th of March. This year, that they had been compliant with their conditions of the visa prior to the outbreak of coronavirus, and that they would have left the UK within the terms of their visa, but could not due to the virus. They didn't have to do anything, it was an automatic extension. For those who lived in China or live in China, but are not EEA nationals and not Chinese citizens, they had to contact the Home Office, but were being given extensions in line with Chinese citizens up to the 31st of March 2020. Now, obviously, things moved on somewhat when we went into lockdown on the 24th of March 2020. By that stage, there was a large number of countries that had closed borders. There were difficulties with air travel, were only admitting certain people into their territories. And at that point, the Home Office extended their policy to all nationalities and extended the date of the policy to the 31st of May 2020. Those who'd already had the automatic extensions come within the terms of this policy as well. There are, however, some differences, and it's important to note that it is no longer automatic. There is an online form that needs to be completed. It requires fairly basic personal information, visa application numbers, Home Office reference numbers, that type of information. But you also need to explain why it is you cannot leave the UK. So because of flight disruption, because you're having to self-isolate. So it's not just a simple, you fill a form out and just give your personal details and get the extension. You do have to provide an explanation, and that must lead to the conclusion that there must be a risk the Secretary of State may, it's unlikely, but may reject an explanation given why you haven't left. You should, within 5 working days, get confirmation from the Secretary of State that your leave has been extended to the 31st of May 2020. There have been various issues raised with the legality of this and the legal basis on which the Secretary of State is just extending people's leave. Because you're now having to complete a form, I think one of the issues with 3C's perhaps been resolved in that you are, I think, arguably making an application. But I think you need to be careful if that you haven't got your confirmation through before your 3C leave expires. It could be said, well, you haven't really made a proper valid application. It doesn't extend it in the same way that making a formal valid application to the Home Office would. Just something to be aware of, and making sure you get those applications in, I would suggest, before leave to remain expires, before the visa comes to an end. And bear in mind as well, this isn't a means of extending leave until you're ready to apply. It is very much only for those who would be leaving the UK regardless, or say for the coronavirus situation. So it's not a means of getting your house in order before you make your tier 2 or extension tier 4 application. It really is only for those who are supposed to be leaving the UK and intend to leave. Something that has changed in the last week is one issue that was being raised quite frequently with me by people was, well, if you've got your 30-day visa to travel to the UK because you've been granted your entry clearance for a work visa, a student visa, or to join your family, you're probably not going to be able to travel within the validity of that. And that's obviously been an issue for some weeks now, and people will have visas that have expired or about to expire in order for them to get to the UK in sufficient time before the vignette comes to an end. You can now request a replacement with revised validity dates free of charge until the end of this year. So you will have plenty of time in order to do that. There'll be no charge, as I say, and it will give people quite a lot of flexibility about when they decide to actually travel to the UK. That's for those who've already got their entry clearance issued but have been unable to travel for reasons due to COVID-19. Moving on to applications for further leave to remain. Obviously, a lot of people will be needing to make those in the near future. Important to note that there are no concessions regarding meeting the requirements of the immigration rules at present. There are, I think, a couple of issues that arise, obvious issues that may arise with people not being able to apply for extensions or having issues in meeting the rules for extensions, minimum income requirements, also English language. The minimum income requirement, of course, you could have lost your job, you could have been furloughed and be on 80%, you could be self-employed and earning a lot less than you previously did. And obviously hope that once the situation resolves itself, you go back to your previous level of earnings. Applying for further leave to remain at the moment may cause you problems in evidencing your income and that you meet the 18,600 or the higher amounts if you have dependent children who are non-British as well. So that's something to watch out for, and at the moment there is no provision for any latitude in relation to that. English language, of course, you have to have taken a test at the requisite level, and I think this is more going to be an issue for those in country than out of country. But you obviously need to, for example, applying for an extension of leave to remain as a family member may need an A2 test. You may be unable to take one of those at the moment. There is provision in the rule to say, well, there are exceptional circumstances outside of my control that mean I can't meet the test, and that may assist you there. There's also the opportunity to submit further documents, and someone commented this morning that, well, you'll have 6 weeks, so you may be able to then, and the other suggestion I've also made when giving this talking to solicitors who've raised this point with me as well, submit the application in time, don't delay it, make representations as to why you can't meet the English language requirement at the moment, evidence that you've booked tests and they've been cancelled, or that you just can't get a test because of the current situation, and undertake to submit a test as soon as you reasonably can take one, making sure you submit evidence of the booking, but asking the Home Office to withhold making a decision on your application until you've been given an opportunity to at least attempt an English language test. So there are perhaps ways around the English problem, but I think it is something you need to be alert to, that at the moment there are no concessions on that point. One thing where there is a little bit of latitude being given to people is in-country switching is now being allowed where it was not previously allowed. This will obviously help tier 4 students who are coming to the end of their leave and want to apply as tier 2 migrants, whereas previously they'd have to go back and apply. They don't need to. I think it may also help certain family members. If you're here on a visit visa, you may well be able to switch. It's not going to help those who don't have leave to remain, though. You will need to have some form of leave to remain. But it is now allowed that you can switch in country, provided that the leave to remain you have is due to expire before the 31st of May 2020. And the important point there, it's not when you make the application, it's when the leave to remain expires. It must be before that date. So you can't try and make an application before the 31st of May, hoping that although your leave expires on the 5th of June, that you can benefit from this. It's not going to benefit you. Of course, one thing to keep an eye on is this date of the 31st of May may very well be extended further, so it may be that others will benefit for it. So it's something to keep an eye on, but at the moment, the key date for a lot of these provisions is the 31st of May. If you are switching in country where you previously couldn't, you still have to meet all the requirements of the rules, and you still have to pay the normal application fees and immigration health surcharges. Moving on, there's obviously been quite a lot of publicity about NHS workers, and they've been put in a slightly different category to other types of workers, and they've been given certain preferential treatment by the Home Office because of the particular role they're currently playing in the pandemic within the NHS. They're all going to get an automatic 1-year extension of their leave to remain. Now, initially, this was doctors, nurses and paramedics and their family members. But last week, on the 29th of April, the Home Office indicated that there'll be a much wider list of frontline workers that I think was published on Friday. And that includes people like pharmacists, dentists, biomedical scientists, midwives. It's quite a lengthy list now of other healthcare workers who are going to be able to benefit from this 1-year extension of their leave to remain. It also applies to their family members as well. It applies to all those whose leave to remain expires before the 1st of October this year. They won't have to pay any fees or any immigration health surcharge in respect of this 12-month extension they are getting. Their employer will assist them with whether or not they are eligible, and they will need to send their biometric residence permit to the Secretary of State and will be sent a replacement with the new leave to remain expiry date on that. They won't need to do anything else. It does apply to all those who work within the NHS who are entitled to work under the terms of their visa. When it first came out, there was some confusion as to whether it was limited to those on Tier 2 visas, maybe Tier 4 visas, who were here either studying or working within the NHS. It has been confirmed that no matter what type of leave you have, provided the work you are doing is permitted, you will qualify. So if you are here as a spouse, you will also be eligible for this free 1-year extension. If you've already applied for further leave to remain because your visa was due to expire around now, you might be feeling slightly disgruntled. The Home Office have now added to the website that you can contact them to withdraw your existing application and apply for a refund of the fees that you've paid at the moment. Obviously, if you pursue your application, you may well get a longer period than 12 months, but at this moment in time, you may just be concerned about getting your extension and not paying that extra that extra year that you may have to pay later down the line. There is one caveat to this though. You don't appear to be able to do this if you have provided biometrics already to the Secretary of State. I don't quite understand the justification for that, and whether there'll be further provision for those who are a bit further into their application process. I don't know. A couple of other important points about people working within the NHS. There's now no restrictions on the number of hours that you can work or volunteer if working as a doctor, nurse or paramedic, and that has been extended. I haven't amended the note there, but it has been extended to all frontline workers that are on the list. If you have leave to remain in the categories that are highlighted there. And there's also an extension of a deadline for pre-registration nurses to take their structured clinical examination, their occupational structured clinical examination. So they don't have to be worrying about exams at the moment. Another group who are likely to be adversely impacted by what's happening with the current situation are Tier 1 entrepreneurs. There will be no doubt a number who will have had their businesses disrupted due to the present situation, and the Home Office have recognised that they therefore may not be able to meet all the requirements that they need to meet in the short term in relation to visa extensions and indefinite leave to remain applications. So what the Home Office have done is a number of concessions and things that are available to those to assist them. So you no longer need to employ at least 2 people for 12 consecutive months each. You can make up the 12-month period by multiple jobs across different months. So that may help some who've had to maybe furlough staff or lay staff off because of the current situation. Important point to note, however, time when employees are furloughed will not count towards the 12-month period. So if you've got people furloughed until the end of June, those 3 months, 2 or 3 months that they've been furloughed will not count towards your 12-month period. If you've not been able to employ staff for the 12 months in total by the time you come to apply for your extension because of these particular problems that we're having with COVID-19, you will be allowed to temporarily extend your stay to allow time to meet the requirements. So you're not going to get your indefinite leave to remain if you haven't met the requirement, but you'll be given more time. Equally, you're not going to get your full extension, but you will get that extra time to enable you to meet these requirements. These concessions, if I can put it that way, will continue for applications made after the 31st of May 2020. So there isn't that cut-off point with applications for this, because the Home Office are recognising that this will impact on Tier 1 applications made later in the year, maybe even into next year, because of the problems that people are currently facing. But it will have to be on the basis that the disruption is due to COVID-19, and that will presumably have to be evidenced with the application. If you can't meet the requirements because your business isn't very good and it's not doing very well because it's not a great idea, or you've got other problems within it, this isn't going to benefit you. Now, Tier 4 students are also another group who seem to be affected quite significantly by the current situation, and the Home Office have brought in a number of changes to how they can study. I'm going to go through these and the sponsor changes relatively quickly, so we can focus on a couple of other points in tribunal procedure in a little bit. But for Tier 4 students, distance learning is now allowed, whereas previously it was not. If you've been issued with your Tier 4 visa but you've not travelled, you can commence your course by way of distance learning, and the sponsorship does not have to be withdrawn. Students whose leave to remain expires between the 24th of January and the 31st of May, who would otherwise be unable to extend in country, will be able to do so. And for those who are unable to complete their course of study within the current period of leave due to COVID-19, they will be able to apply in order to complete their course. So if they wouldn't otherwise have had that option available to them, the Secretary of State is saying, well, I will permit you to make that application. Those who need more time to complete their course as a result of COVID-19 will be exempt from showing academic progression. So those two should help people whose course has completely come to a halt, because of course some will just simply not be suitable for any distance learning, or there's some distance learning but not sufficient, or people who due to ill health fail exams and can show it's due to COVID-19, they will be exempt from showing that academic progression when they come to apply for extensions. Just a couple of other things just to be aware of when advising clients. There's no need to register with the police at the moment if you've applied for an extension since the 21st of March, or if there's been a change in circumstances that you otherwise need to register. You're currently exempt from doing so, but obviously when the current social distancing measures come to an end, the requirement will be reintroduced and you'll have to register any changes or register with the police if you haven't already done so. Limitations on working hours have been lifted, and those whose sponsor has suspended all study, regardless of where they're working, can work full-time hours. They will be treated as if it is vacation. If you're doing distance learning, however, that doesn't apply, and the restrictions on term time working will remain. And you can volunteer as an NHS volunteer responder. We come to one of the points that I think doesn't necessarily reflect what the Secretary of State has been saying in relation to that nobody should suffer a detriment in the immigration system because of COVID-19 and circumstances beyond their control. It's arisen because of the current pandemic. And that's that the Secretary of State is saying that a discretion may be applied if an extension is sought that will take the applicant over the normal period allowed on a Tier 4 general visa. So I'm sure you're well aware, you're only allowed to be here for a certain period of time up to certain levels of study. And if you've got to the point where you can't have an extension because you've been here too long and you're still doing your master's degree, for example, you wouldn't normally be able to continue, you wouldn't get an extension of your leave. The Secretary of State is saying that, well, a discretion may be applied if the reason is COVID-19. You would have thought they'd be a little bit more forthright about and forthcoming in respect of that and be saying, well, actually, yes, we will give you an extension if the reason you haven't completed your master's is due to COVID-19. It's hard to think of a better example of how somebody may be prejudiced by the current situation if they can't complete a course of study because there's been a break in the distance, break in the course being taught, they've had to take time off due to ill health, which has meant they couldn't complete it within the time of their visa. But at the moment, all we've got is there is a discretion, and we don't know how that's going to be applied by the Secretary of State. And just a quick note, the graduate route is still scheduled to start in summer 2021. Just quickly on short-term students, they can now switch in-country on an exceptional basis until the 31st of May 2020. So they can switch to Tier 4 until then. After that, we'll have to see whether there's a further extension of that 31st of March 2020 date. And if they do need a short extension of leave, because their leave is due to expire before the 31st of May, they should get that upon a request for that. They'll also be entitled to take on a study further course other than the one which they originally entered the UK to undertake. And they can start a new course in the UK. Sponsors' duties, there's obviously a number of issues that's arisen in relation to both employers and higher education institutes in relation to their sponsors' duties. Going through them, they're relatively similar changes to both. The first is obviously that there is no need to report student or employee absences related to coronavirus, and you don't need to withdraw sponsorship if because of coronavirus a student is unable to attend for more than 60 days or an employee is absent from work without pay for more than 4 weeks. So you're not going to lose your sponsorship because of issues relating to ill health with coronavirus or have to self-isolate, for example. Until the 31st of May 2020, you can study through distance learning either in the UK or abroad, and you can start your studies without the need for sponsorship to be withdrawn. And you don't need to tell the Home Office that students have switched to distance learning. But if a student has permanently withdrawn from their course because of reasons unrelated to coronavirus, then that, of course, must be reported in the usual way. People who've got certificates of acceptance of studies and certificates of sponsorship can still continue to make their Tier 4 applications even if they haven't yet applied, if they've already been issued with those documents. It's recognised by the Home Office that start dates are likely to change for employment and courses. That will be considered on a case-by-case basis. There'll certainly be no automatic refusal because a course can't be started on a particular date due to the current situation. And there's a little bit of help there for those who need to have a B1 level of English. If we've got a higher education provider with track record of compliance, they can self-assess the students. That resolves that problem in relation to Tier 4 students. Students are also entitled to start their studies before their visa application is decided if they're applying in country for an extension, that a CAS has been assigned and the application was submitted before their current visa expired. The institution has seen evidence of this. So it's not going to help overstayers, but it will help those who've applied in time to continue on with their studies as best they can in these circumstances. Reporting responsibilities will start from the date the CAS is issued, and if the application is unsuccessful, then of course studies must be terminated. Again, for employers, there are similar changes. There's no need to report that employees are working from home, though other changes will still need to be reported. Employees can start work before applications have been decided, provided they've been assigned a certificate of sponsorship and that they've submitted their application for leave to remain before their current leave expires, and they're employed in the same role as the one that is on the certificate of sponsorship. So you can't submit a certificate of sponsorship in one job, start another job, but there is the opportunity there to start the job that's on the certificate of sponsorship. Again, reporting responsibilities will begin from the day the certificate of sponsorship is assigned, and any changes that will impact on the application must be updated on the certificate of sponsorship. The sponsor management system is not going to be used at the moment for reporting information, but employers must maintain records of all relevant information. And of course, if the employer's application in due course is unsuccessful, then of course they can't continue to work. Just a quick word on the furlough arrangements, because obviously various applications require people to have earnings at a certain level. You can use the furlough arrangements as an employer, provided any changes to earnings are part of a company-wide policy and you're not using it as a means of just paying your foreign national workers less, and it's being used to avoid redundancies. It's being used properly as the government intend, that all workers are treated the same, that changes are temporary, and at the end of the furlough period, salaries return to previous levels. It's not a means of reducing down how much you pay people on a longer term basis. Right to work checks can be done. So can you still hear me?
I can hear you, Emma. Sorry.
Yes, it's just saying that I've been muted. That's all right.
No, that was me in error, trying to find who was the person that was guilty of not muting themselves. I'm sorry.
Don't worry, I'm not the greatest with technologies, I think we all know. Right, okay, going back to right to work checks, just a brief note on that. You can do them remotely, but once we go back to an end to the social distancing measures, you will be required as an employer to physically check the documents and undertake the usual checks. But in the short term, you don't need to comply with the usual requirements there. But you do, of course, have a duty to make sure that you've looked at the documents remotely. Want to say a little bit about immigration detention and bail applications. It's been indicated by the Home Office that they have no plan for wholesale systematic releases of those in immigration detention. About 350 detainees were released in March. In light of the current situation, there was a review, appears to have been some form of review of those in detention, some were released, but the Home Office has been very clear that they've got no intention of a wholesale systematic release. Detention action did bring a challenge to the policy that they weren't releasing all immigration detainees, but the High Court did reject that challenge. There were a number of commitments made to safeguard detainees in relation to hygiene, in relation to ensuring social distancing can take place, that you have the ability to self-isolate whilst in detention. They also undertook to proactively review the detention of all immigration detainees. It was indicated that that was due to finish on the day of the detention action proceedings. It was unclear to me whether it had actually been completed, but a letter was sent to Mr. Clements, the president of the first tier tribunal, earlier this week by the Home Office, might have been the back end of last week, raising a number of issues with bail applications and how many of them are being granted. And they did indicate in that letter that they had conducted a review of all immigration detainees, and they were certainly they were satisfied that it was appropriate to maintain detention in those cases. Home Office getting very upset about the number of people who are currently being granted bail. And we'll come on to that in a moment. One of the things that came out of the detention action litigation was that it was said that the Home Office have a very strong presumption at present against new detentions for people who are facing removal and who are from approximately 50 different countries. This covers countries such as Albania, Jamaica, Pakistan. I think Nigeria was included in there, because of the difficulties of removing people to those countries at present. It's worth keeping an eye on that in the list that they've got of who they're saying countries they can't remove to, or where there are very real difficulties. But it is important to note, however, that there is no presumption or no blanket policy of no removals at the moment. And in the letter that they actually wrote to Mr. Clements last week or the beginning of this week, they actually indicated that they have successfully deported people to Poland, for example, since the pandemic started. So they are still, where they can, looking to remove. And they also did indicate that they were in talks and negotiations with various countries about removing people and the practical difficulties and the practical hurdles that they have to get over in relation to that. So be aware there's no blanket policy. What there is a blanket policy on is that there is no voluntary assisted removal at the moment. So that programme has been paused for the time being. Moving on to just bail applications, although the Home Office are satisfied that the people that they have in detention should be there, immigration judges as a whole are looking very favourably on applications. I know that certainly Adam's done applications recently, which judges who are normally quite difficult and hardline with certain bail applications have been far more liberal in terms of their approach. They are triaging them. So what they're doing is they're looking at the papers a day or two before the bail hearing is due to be heard. and they're considering whether they're minded to grant. If they are, you'll get a notice through saying that the judge is minded to grant bail with proposed conditions, and you have an opportunity to respond to that. The Home Office also obviously have an opportunity to respond, and one of the things that Mr Clements was getting rather upset in his letter, and not unreasonably, is, well, we've been undertaking this minded to grant exercise, you're objecting to everyone and then coming along and making no further representations over and above that which was in the papers before the judge minded to grant. And the Home Office, in his response to their letter complaining about the number of grants of bail, did point out that the judges are simply applying the law, the guidance and procedures as they always have done. So I think there's been a little bit of fallout between the first tier tribunal and the Home Office in respect of this, but what does come out of that is it appears countrywide bail applications are being favourably received by the judiciary at the moment. And just when making those bail applications, just a few points to consider. Although there's no blanket policy of no removals at present, the reality is it is very hard for the Home Office to remove people at the moment. There are very real practical difficulties. There are hardly any flights. And in the vast majority of cases, you're going to easily be able to persuade a judge that there's no imminent prospect of removal. Low risk of reoffending and perhaps absconding, you need to look at that, I think, in light of the current restrictions we're all under and the current restrictions we're all facing on our movement. There's higher presence of police, they're asking people questions, people are less likely to be out and about. I would submit you can argue quite clearly to immigration judges, and they appear to be receptive to it, that there is a lower risk of reoffending at this time. Judges are also entitled to take into account under the bail provisions other matters, such as, I would say, the risk to a particular applicant if they were to be infected with COVID-19 in the custody setting. It's not going to be applicable to all, but if you've got somebody with very poor health, somebody who's particularly elderly, you may well be able to say to a judge as a final point that might just push the bail application over the final hurdle. Well, actually, this is someone who is actually very vulnerable, and if they do catch this illness, potentially will be very, very unwell with it. I think they are reluctant to find a change of circumstance on the basis of COVID-19. But certainly the feedback I've had is that judges are more willing to say, well, because of the COVID-19 situation, there's been a change in circumstance because things are not being dealt with as quickly as I anticipated they would be when this bail application was last before me. So even where you've got people who've had fairly recent bail applications, you may well be able to establish that there has been a change of circumstance. Just another couple of points on immigration bail. There's been a pause on immigration reporting conditions since the 17th of March. Make sure your client's details are up to date with the relevant reporting centre, because when they need to resume, they will be contacted directly by them. I understand it will be by text message. That's certainly the current plan. So if you've got concerns that the Home Office don't have your client's up to date details, just email the reporting centre that they are reporting at. Now, no recourse to public funds. My session in relation to this has been somewhat thrown this morning because we've had judgment in a case that the current policy is in fact a breach of Article 3. I haven't seen the judgment. I don't know how wide-ranging that is. This doesn't necessarily, having read the brief summary I've seen, it seems to apply to the policy as a whole, because it appears this is a young child who was being left in a very, very vulnerable and precarious position over a number of years, and not just because of the present situation. So I think this is something that perhaps I'm going to skip over, other than to say that at the moment, the Secretary of State's position is there's no blanket policy change to the restrictions, but she's going to have to revisit that in relation to the policy. But those with a no recourse requirement can access support, regardless of what happens to no recourse to public funds, in relation to testing and treatment for coronavirus, food and medicine deliveries if shielding, statutory sick pay. If they've contributed through the National Insurance Scheme and tax, they're entitled to employment support allowance that they would get on the basis of those contributions. And also on the job, under the job retention scheme and self-employed income support scheme, they're perfectly entitled to receive support through that. So none of that comes into play when looking at whether you need a no recourse to public funds restriction removed. At present, you need to apply and you need to show your circumstances as such you can't provide food or housing for yourself or your family, or a child is at risk because you're on a very low income. What's going to happen with this, I just don't know in light of the new judgment. There are presently consequences applying to have your new recourse to public fund requirement lifted, and that if you are here on the 5-year route to settlement under Appendix FM, they'll put you on the 10-year route, and if you go back to the 5-year route, you start again at the moment and crowing your 5 years. But that is all subject to what the Home Office are going to do in light of this case, and I can't say too much more about it because I haven't seen the judgment yet. Just a brief summary. Right, that brings us on to tribunal procedure. Hopefully I can take the main points fairly shortly in respect of this, but they are important. We've had a pilot practice direction that covers all tribunals, and what it effectively allows the tribunals to do is to look at cases on the papers and deal with them on the papers if they believe it is suitable for them to do so. The anticipation from the senior president of the tribunal, Sir Ernest Ryder, is that parties will be notified of a preliminary review as to the outcome of a case, and they can make representations based on that, and that there may need to be a hearing after that. But it very much gives tribunals the power to get on with things on the papers. There is an operational update from the first tier tribunal and all courts, which is available on the HMCTS website. It's updated daily, but not necessarily for the tribunal. And as I'm sure you're all aware, as far as the first tier tribunal are concerned, all face-to-face hearings are suspended. Bail applications are proceeding and are being given priority, but they are being done by telephone at the moment. You're now required in all protection claims, effectively, or all non-human rights and EEA claims, to use the online procedure. If you cannot do so, you need to explain why. And that's for obviously lodging your appeals. For those appeals that are already in the system, I'm sure you've all seen them, the standard directions, which are adjourning everything and listing a case management hearing via telephone or Skype. At present, it will be via telephone. I think some have started this week in Manchester and Bradford, because the Home Office have no facilities to use Skype. It may change to Skype or the cloud platform that's being trialled at the moment. I don't know. Just some points to be aware of in these standard directions. They are requiring work to be front-loaded. They are taken, it would appear, from the pilot project that's been running in Manchester, which requires much more work to be done earlier on to try and resolve cases at an earlier situation, at an earlier point in time. There's a requirement that all evidence that the appellant intends to rely on needs to be sent electronically to the tribunal together with an appellant skeleton argument. Having drafted some of these, they are lengthy documents and they are a pain to draft. They need to be done within 15 working days according to the standard directions. The directions I have been seeing have certainly had a specified date on them. So look out for that date. Happily, it doesn't seem at the moment we're not having to calculate it for ourselves. The tribunal is telling us. The respondent's then required to serve a response. If they don't, it will be assumed that the respondent does not take issue with the submissions contained in the appellant skeleton argument. It is fair to say that the one or two I've heard about simply say, we maintain our position in the refusal letter. We don't agree with the appellant skeleton argument, not really engaging with the system at all, which I suspect is hardly a surprise because I suspect the Home Office simply don't have the staff or resources to respond to this requirement. The documents that have been submitted will then be considered, and it'll be considered whether an oral hearing is in fact required or whether it can be dealt with in the papers. Just a point on that, I've actually been addressing why it can't be dealt with on the papers in my skeleton argument, so it's there in front of the judge already, although an opportunity is going to be given for you to make representations on that point. And in terms of the appellant skeleton arguments, whether it's an international protection case, you need to do a summary of the case, a schedule of issues, and you must respond to each of the issues raised in the refusal letter. You can now see why they are difficult and time-consuming to complete. Maybe not difficult, but just time-consuming, and that they are becoming quite lengthy documents. Where it's not considered appropriate for the matter to proceed without hearing, consideration will be given to a hearing the appeal by remote means. At the CMR, you're going to have to be positioned to provide quite a lot of information, but it's important to note at the moment, the expectation appears to be that bundles will not exceed 50 pages without the consent of the tribunal. I don't see how that can work in lots of cases. You have an expert report and asylum claim, they're often 30 or 40 pages. You have a case involving people who are said not to be in a genuine relationship, they're going to want to produce all the evidence of their relationship and of their contact. That's going to be more than 50 pages, one would hope. Financial requirement cases, especially if you've got someone who's self-employed, there's going to be pages and pages of evidence to meet the requirements of Appendix FMSE. So I think that is wholly unrealistic. Generic bundles will not be accepted, so you can't just stick in the bundle you always stick in for an Afghan asylum claim, an Iranian asylum claim. It's going to have to be targeted to that actual appeal. We are awaiting further guidance from the first-tier tribunal, a further practice direction. It has been held up. We should have had it 2 weeks ago, because as I'm sure a lot of you who do legal aid work will have immediately noticed, there's a problem. There's no funding in place for these appellate skeleton arguments, and if the case is subsequently withdrawn, you won't get a penny towards the hearing fee either, so you won't get anything. There's obviously issues for privately paying clients as well, who will be ultimately paying out more because of the additional work we're all going to have to do. But I also think, as I said, there are issues operationally for the Home Office, and I think they may be making representations. I guess, I don't know, but I can see problems that they will have with complying. I'm conscious of the time, but just to run through the upper tribunal information as well. Again, everything's been adjourned in the upper tribunal. With statutory appeals, they're being judicially case managed, and directions are being sent out, which we'll come on to in a moment. With judicial reviews, the operational guidance is slightly out of date now. We had amendments again last week. You can now lodge non-urgent judicial reviews by email. You can still lodge them by post if you wish to do so, but you now have the option of email as well. We've had an upper tribunal presidential guidance note. I've picked out of it some of what I think are the really important paragraphs. The first one, paragraph 9, just the upper tribunal telling us all they've got the power to decide these cases on the papers, and they can do so without our consent. The good news is they do, however, recognise that they should have representations on that point. And you'll note paragraph 11, the judge will consider whether, in all the circumstances known to the judge, it would be appropriate for the upper tribunal to decide whether there's an error in the first-tier tribunal's decision and whether it's material, and whether that can be decided on the papers. You get permission to rely on further written submissions. You're not limited to just your grounds of appeal. The respondent will then get an opportunity to respond, and then you can reply again as the appellant if it's your appeal. So you can make further written submissions if they go down this route. You can also make representations about whether or not there needs to be hearing. My personal view, for what it's worth, is that really you should be having a hearing for material error of law issues, because if it's just being done on the papers and you have no indication of what the judge's view is, you can't respond to it. You don't know if they're with you, you don't know if they're against you, they don't know if you misunderstood something, you can't develop your arguments, you can't seek to persuade them in the same way that you can with oral advocacy. I just think it's dangerous to proceed on written arguments alone. And of course, one would have thought material errors of law hearings were perfect ones to do remotely. The tribunal are emphasising, though, at paragraph 17, that these directions at 11 to 13 apply to material error of law issues only. If one is identified, there will be further directions as to how the matter will proceed, and it is recognised that there's more likely to be a need for oral evidence, and therefore it is more likely that there will be a remote hearing. It doesn't always follow that there will need to be further oral evidence if a material error of law has been identified, of course, but in a lot of cases there does need to be further evidence. So they are going to issue further directions. So don't worry when you get the first set of directions, there will be an opportunity for you to make representations as to the final decision in the case of an error of law is found. The default position is any hearings will be remote, either by video link, telephone, or other means of instantaneous two-way electronic communication. I'm still yet to work out what that means. I don't think they're really thinking they're going to start conducting hearings via WhatsApp. But there we go. They've left themselves a very wide range of options there. In terms of dealing with documents, you can still file them by post, but if it's going to remote hearing, you need to file them electronically as well. Paragraph 24, they've given some guidance as to what they want in these bundles. They want them as small as possible. Target what you need to have in there, and note, you don't need to provide copies of cases you're relying upon, provided you provide the citations and the text of the judgment is publicly accessible online. The same with other documents, so background material that are publicly and easily accessible online, you only need to provide the parts relied upon. So you don't need to provide all the US State Department report, provide the paragraphs you're relying on and the reference to the online site where the full document can be found. So that should help us a little bit in keeping the bundles down in size. Just a little bit about procedure and remote hearings. They'll be listed on a day at different times, so you will have a time slot and staff members will be in contact with you to establish contact and the arrangements for the hearing. If it's necessary to hear oral evidence, they will, if possible, deal with it by remote hearings. I mean, I think we can all think of lots of reasons why it's not going to be suitable to be dealt with remotely, especially if you need anything in the way of extensive evidence. I just can see things going wrong. If you've got more than one witness, how are you going to prevent witness contamination? Even if you've only got one witness, how do you know the friend isn't sitting in the room? I can see difficulties with interpretation, and I can see the difficulties as well in the judiciary or the judicial panel looking at it, not getting the same flavour for the witness and their credibility that they get from all that non-verbal communication that will be lost because of the video link. If it's necessary for there to be a hearing, the tribunal will try and accommodate it in light of the current pandemic, but where precautions can't be put in place to protect people, it will have to await the current social distancing measures coming to an end. Paragraph 33 of the rules deals with urgent judicial reviews. There's an email address to file online. If it's urgent and you need to make an out of normal court work hours application, the out of hours service remains in place and is to be used in the usual way. If you are refused without a hearing, you can renew your hearing orally. That will take place by telephone during the pandemic. That's in urgent cases. 35 is out of date because we've had an amendment, as I say, last week, that they can now be filed by email as well. And we'll come on to that in a moment. And the general provision with immigration judicial reviews is that there will be a hearing where permission has been granted. That can be dealt with by remote hearing, but it doesn't appear that they are even beginning to suggest they could deal with judicial reviews on the papers. From the 30th of April, so last Thursday, I think this came out on the Wednesday, as I say, you can now file non-urgent JRs by email as well as by post or at the fees counter when it reopens, but you are now going to have to pay a fee. You need to make an online payment, but if you're sending it by post, again, checks and postal orders are still available. So that, I think, is the last development that we've had in terms of judicial reviews and upper tribunal procedure. And with that, that brings my whirlwind tour of changes to policy and practice in COVID-19 to an end, and I'll hand over to Adam.
Thanks, Emma. That's fantastic. I'm just going to share my screen and get my PowerPoint up. Let me just have a look. Hopefully my, yeah. I think it's still got, Emma, have you stopped sharing your screen?
I think so.
Let me just try again. Let me try again and share mine and see where mine has gone. And then here we go. There you are. So there we are, brilliantly. Well, thank you everyone for tuning in. It's fantastic that so many people have been on for all three sessions. Forgive me for my headphones. I look like a teenage boy playing games in a bedroom. And I brought this afternoon for the final one my Trust Me, I'm a Barrister mug. So if I say anything dodgy, I will flash up my Trust Me, I'm a Barrister mug. And as Emma said, things are very fast moving at the moment. And during Emma's talk, Project 17, it's project17.org.uk, in fact, posted some content from the oral judgment in the no recourse to public funds case. And it looks like the focus is very much on Article 3 and avoiding destitution and people being put in a position of destitution. But they say our decision will not affect the ability of the Secretary of State to continue to make grants of leave to remain in the United Kingdom, subject to a condition of no recourse to public funds in the normal run of cases. So very much focusing on those who are at risk at Article 3 and detention. Now, I'm conscious it's 10 to 5, and I want to respect your time and give 5 minutes at the end where Emma and I can answer the questions that people have been posting in the chat. So what I'll do is probably go a bit faster and shorten my session and just give you some highlights. But first, before I get to my notes, some hot off the press stuff with the latest case law. In terms of health cases, we've seen a very helpful development in Article 3 and health cases, with the Supreme Court ruling in AM Zimbabwe and finding that they can depart from the case of N. Now, as you may know, AM Zimbabwe was in the deportation context, very serious criminal offences. He had HIV, had some trouble with different antiretroviral medication, and it was unlikely that he was going to get the proper antiretroviral medication in Zimbabwe. In the lower courts, the case has been run on an Article 8 basis, accepting that the N test, the sort of deathbed test, couldn't be met. But by the time the case got to the Court of Appeal, we'd had the judgment in Paposhvili. And Paposhvili had extended N to where somebody would be at a real risk of being exposed to a serious, rapid and irreversible decline in health, resulting in intense suffering, or to a significant reduction in life expectancy. The Court of Appeal found that they were bound by the N judgment and really interpreted Paposhvili in a really minimal, tight way. So the case went up to the Supreme Court, and the Supreme Court found, as I've said, they could depart from N. Paposhvili did apply, and that the Court of Appeal's approach had been too limited. They also give some helpful evidential guidance in terms of burdens and evidence. And if an appellant can produce evidence capable of demonstrating the substantial grounds for believing that they'd be exposed to a real risk of Article 3 ill treatment, that then the burden shifts to the Secretary of State to dispel any doubts raised. But that evidential burden is still very high, and you still will want to think of running Article 8 in health cases where you can bring in other factors such as the family life and the ties and dependency and those kind of things, and also consider running 276 ADE. Now, second hot off the press issue is the new Afghanistan country guidance case. As you may be aware, AS was remitted by the Court of Appeal to the upper tribunal because they'd made some statistical blunders in their original judgment. This judgment considers a number of issues in relation to Kabul. Firstly, if you're a low-level interest to the Taliban, you're not at risk. Secondly, that in general, there is no Article 15C risk to individuals returning, despite the widespread and persistent armed conflict. But the important part is at Roman 3 of the head note, and that's about internal relocation. Internal relocation is generally reasonable for a single adult male in good health, even one who doesn't really have good connections with Kabul. But Roman 4 goes on to say that in the particular circumstances of an individual applicant, they must be looked at, and they give examples of the individual circumstances that must be looked at, such as age, nature and quality of support, connections, mental health, the time they've been out of the country, and that's carried on in Roman 5. And that'll be particularly relevant if you've had, say, an Afghan minor who's been out of Afghanistan for a significant length of time. They also confirm at the end which parts of the country guidance, the previous country guidance, in terms of specific categories like women returning, are still relevant and applicable. So have a look at that. But that's the hot off the press stuff. Let's get into my main sections now. I'm going to briefly look at Article 8, asylum, EEA, and deportation, because we've heard so much about COVID, our brains have probably forgotten, you know, the substantive law. We've been at home binge watching Tiger King on Netflix. So let's give us some substantive law to remind us what it's all about. Article 8 first. You, as Emma said, obviously a lot of hearings now are being conducted on the papers initially, and your written advocacy is really important. So feel free to use the slides and take the key extracts from these cases to put in your appeal skeleton arguments and the like. So the first case is a negative case. It's the case of Eunice. I'm sure a lot of you have been very troubled when you saw that. If there's any presenting officers on the call today, don't read this case, not worth your bother. Now, Eunice, difficult case, Pakistani national, spent most of her time living in Dubai, comes to the United Kingdom in 2016 on a visit visa whilst pregnant. Her British partner is here. She has a British daughter in the United Kingdom subsequent to her arrival. Her partner has 2 British kids from a previous relationship. Make an application in 2018. That's unsuccessful. Case gets up to the upper tribunal, and the Secretary of State accepts there are insurmountable obstacles to the appellant's family life continuing outside of the UK, and that it would not be reasonable or proportionate for the family unit to be indefinitely separated. Now, you'd have thought, wow, there's an open goal, we're going to win this case. But no, the upper tribunal have other ideas, and it's a presidential panel. Now, it's unfortunate that significant credibility findings were made, and they found the appellant and her partner exaggerated their evidence about ties to Pakistan and partner's financial situation. And they found it was likely, or that either now or in a short period of time, partner would be able to meet the financial requirements in Appendix FM. And therefore, if an entry clearance application was made, it would only take 4 to 9 months. Now, the representatives had argued the Chikwamba argument. What's the point in sending them back to apply for entry clearance? And in this case, mum was the primary carer of daughter, so daughter would likely have to follow mum. So they argued that Chikwamba, what's the point if the immigration rules would be met? Now remember, Chikwamba doesn't bite unless you can show you would meet the rules on an entry clearance application. See the case of Agiarco or the Court of Appeal decision in Core. But you'll see there from point 1 on your screens that the upper tribunal found that even if you argue there's no public interest because the rules would be met, the tribunal still have to consider the factors in 117B, which says the maintenance of effective immigration control is in the public interest. So they find that her immigration history, as somebody who perhaps deliberately came as a visitor with no intention to go back and had her child here, her immigration history outweighs the fact that the immigration rules on entry clearance would be met. And they cite the examples that Lord Brown gave in Chikwamba, where entry clearance could be insisted on, the case like Akinci. But the difficulty I have with this is Akinci's immigration history was far worse than this. I think it's a very hardline case and particularly difficult. They raised a section 117B argument because, of course, there was a British qualifying child. And we know from AB Jamaica, look at 2 at the top of your screen, and JG, that we have to assume the child would leave. But then they say, well, KO Nigeria talks about a real world situation, and assessing the reasonableness in the real world situation, well, the child's only going to be out for 4 to 9 months. Therefore, it would be reasonable for her to go back. Now, I'm troubled by that because we all know entry clearance applications take much longer than we initially plan. And I think the tribunal, rather than looking at the real world, are actually speculating. They go on then to look at a Zambrano argument that the child would be deprived of her rights as a British citizen, a European citizen. And they find, well, yes, there's the case law in Zambrano, but that has to be looked at on the actual facts rather than theoretical possibilities. And given that she's going to be out temporarily, she's not going to be deprived of the genuine enjoyment of her rights. Again, I don't see any sliding scale within Zambrano and the jurisprudence that followed Zambrano. And again, I think it's speculating as to how long she'll actually be outside of the UK. So a very difficult case, and I think it's going to be one that's going to be a bit of a thorn in the flesh. And actually, people might think there's a bit of a tension with the case that follows, Runa. Runa was actually remitted to the first tier tribunal to consider the reasonableness question in 117B, and it'll be interesting to see how Eunice influences that. I don't think Runa addresses the same questions as Eunice does. Runa, again, was a visitor, entered in 2006 and overstayed. She married a British citizen in 2014, made an application for leave to remain as a partner, had a British son. Case came before the first-tier tribunal, who allowed the appeal. Secretary of State appeals to the upper tribunal, has another British son. Upper tribunal find an error of law, and then re-decide the case, dismissing the appeal. And the deputy judge there, Deputy Judge Mandalia, as he then was, he considered, well, could the children stay with dad in the UK? Or alternatively, could the whole family relocate to Bangladesh? And he said, well, because it's not there's not insurmountable obstacles to the husband going, it's reasonable that child would follow the parents. Therefore, in this case, it's reasonable that they all could go. So the case was appealed to the Court of Appeal, looking at the construction as 117B6. Let me give you first something that was said about 117B6, and this is quoting Counsel for the Secretary of State, and it says at paragraph 32, he submits that section 117B6 is to be regarded as a benevolent provision, which can only operate in one way, potentially in favour of an appellant, but never adversely to an appellant. I would accept Mr. Anderson's submissions. What that means is that if you satisfy 117B6, you'll win your appeal. But if you don't satisfy 117B6, that's not the end of it. And as paragraph 33, which is on your screen now, says, still a full proportionality balance has to be undertaken. The appellants had argued, actually, in this case, that where one parent had a right to remain, it would never be reasonable to expect a child to go back. That was rejected, but they did accept that in this, in an assessment of 117B6, a proper fact-finding exercise, paragraph 36, needs to be undertaken in order to answer the sole issue. And the sole issue is whether it be reasonable to expect the child to leave the UK. And in this case, the deputy judge had not asked the correct question. So that's why the matter went back to the FTT. And they also accept that the test is not one of insurmountable obstacles. And even in a proportionality assessment outside of the rules, the test is not insurmountable obstacles. And they reference GM, which we'll come to in a minute. So have a look at Runa, some helpful stuff there you'll want to cite in your appeal skeleton arguments and your submissions. Now, Udin is an interesting case. A lot of you may have dealt with, say, Afghan minors who get leave as an unaccompanied child, and then they apply for an extension when they're an adult. They rerun their asylum claim, and they also run an Article 8 claim based on the family and private life they built up, and often a family life with foster carers. And Udin is one of those cases where a relationship had been built up by a child who'd been placed into foster care, and he developed family life with his foster carers. And at the time his case came before the court, he was now 20. A judge at the first tier tribunal rejected his Article 3 claim and made adverse credibility findings on that. And she used those adverse findings not to believe everything else in respect of Article 8. And this is important. Paragraph 11, the court reminds us that just because somebody may be untruthful about one matter, brackets in this case his history, doesn't mean he'd be untruthful about another, in this case the existence of family life. For those of you who do criminal law, you'll be aware of this. This is called a Lucas direction, but it applies equally in the immigration context. And this is relevant where you've got sort of two limbs to an application or an appeal, an asylum and perhaps an Article 8. The fact you might be lying about one doesn't mean you're lying about another. The other thing the deputy upper tribunal judge did in this case was he said, well, the judge, because the argument was the first year judge had not made any proper findings on Article 8, and there was uncontradicted evidence that from the local authority and the like about the relationship this child had, or he's now an adult, with the foster carers. And it was argued, and the deputy judge says, well, look, this was a carefully prepared decision by an experienced judge who wouldn't have made such an error. Now, while we're entitled to give judges respect as expert tribunal judges, when looking at whether there's an error of law, a judge of the upper tribunal shouldn't just import an assumption that just because a judge is experienced or just because they've written a long determination, it means they haven't made an error. This will be useful again to cite in your grounds, or perhaps your renewal grounds when you're renewing for permission to the upper tribunal. Now, the deputy judge had introduced the idea that foster carers was a commercial arrangement and that there was some special approach to Article 8, the Home Office then argued in the Court of Appeal for foster carers. So the Court of Appeal go through the issues. They look at the Cougarthus Article 8 for adult and adult dependency. And they say, paragraph 31, that in a Cougarthus adult Article 8 case, it's a question of fact, and the key issue is whether there's real or effective, or committed support. And they say, they look at the case of Gissing and they say there's no requirement for exceptional dependence. It's all fact sensitive. And they reject the allegation and the argument that foster carers should come within a special category. And they also say, paragraph 36, that there's no assumption or presumption, either positive or negative, when somebody becomes 18. And in fact, look at the end of paragraph 36. Continued cohabitation will be a highly material factor to be taken into account. And while not determinative, a young adult still cohabiting with a family beyond the attainment of a majority is likely to be indicative of the continued bonds of effective, real, or committed support that underpin a family life. So helpful stuff there. Good summary in paragraph 40 about the nature of the Cougarthus, nothing exceptional. It's to be looked at on the facts, nothing particular about foster care, and no presumption on reaching 18. So really helpful stuff for you there. In terms of general arguments on proportionality and insurmountable obstacles, particularly in cases where you've got precarious relationships, have a look at GM Sri Lanka and also the case of Lal, which covered some of the similar ground. In GM was a student and she got together with her partner while he had leave under the legacy provision. He had discretionary leave at that time. They had 2 kids. And by the time their case came before the tribunal, partner and kids had discretionary under the legacy. Later on, they got indefinite leave. And by the time they got the Court of Appeal, they had a British child. The assessment of Article 8 is summarised by Lord Justice Green in this really helpful judgment. Look at paragraph 29, where he says the assessment of Article 8 outside the IR, the immigration rules, is whether a fair balance has been struck. It's a proportionality assessment. There's no requirement to show exceptionality. We don't have to show some highly unusual or unique factor. And still, we see that in Home Office decisions, Home Office submissions, and in judges' decisions. It's all about the circumstances of the individual case, paragraph 30. Just have a look, actually, when you look at the full judgment, also at paragraph 34, because he gives some helpful guidance on the rights the partner had to give up. Even though he didn't have ILR at the date of the tribunal hearing, the fact that legacy is a path to settlement is something that should be given weight. And the fact if he had to return with his partner, he would lose those rights is something that should be given weight in the proportionality balance. There's also some helpful stuff at paragraph 42 about the rights of children. At paragraph 36, it looks at the little weight provisions. When they got together, they had leave to remain. It wasn't indefinite, so their status was precarious. But the provisions in 117B doesn't say that family life should be given little weight with somebody who's precarious, only private life. So a judge was wrong in applying the little weight provision. So that's helpful. And also in respect of insurmountable obstacles, remember, under EX1B, insurmountable obstacles is the test. But look at paragraph 48. Under a proportionality assessment, it's not the test. It's simply a relevant factor in the proportionality assessment. Let's quickly go to asylum. I've got about 15 minutes left, so I'm going to buzz through the other subjects. And the first thing we're going to look at in asylum is the issue of Christian conversion, particularly through Iran, but we're also going to touch on some HJ Iran stuff and behavior modification. So PS is the new country guidance in terms of Iranian Christian conversion cases. It replaces previous country guidance, and the judges must first decide if somebody is a genuine convert. If they're a genuine convert and they would openly practice their faith in Iran, they're at a real risk of persecution. If they would conceal their faith, decision makers should consider why. And look at this: if any part of the claimant's motivation is a fear of such persecution, the appeal should be allowed. And that applies wider than just conversion cases. If one of the reasons as a refugee you modifying your behavior is to avoid persecution, you're not excluded, therefore, from refugee status. If a claimant 3 would choose to conceal his faith purely for other reasons, then they could practice without persecution. So if there's any motivation of fear of persecution to modify your behavior, you still should be a refugee. They then looked at those who are not genuine, the sort of Danian point, the bootstrap refugee. Now, somebody in Iran is not going to be at risk if they're not a genuine convert, but they may be at risk on the pinch point of return. And we know about that from the case about internet activity AB. So all returning Iranians are subject to questioning. If you tell the Iranian authorities, well, I've claimed to be Christian, you're going to get further questioning. And if you're likely to be in prolonged detention, that could put you at risk. And one of the particular reasons they look at is overt social media activity. And we know a lot of our clients are very active on social media. We've recently had a further decision which looks at church witnesses, and that looks at the weight to be given to church witnesses. Look at Roman 4, and it's significant evidence. See the Scottish case, really helpful Scottish case, TF and MA. Although the upper tribunal disagree that church witness evidence is not really expert evidence, nor is it necessarily deserving of particular weight, and the weight to be attached to such evidence is for the fact finder. But actually, if you look at the judgment, they do set aside the judge's assessment there because she hadn't properly given weight to the church member's evidence and had discounted it just because the church member wasn't aware of the previous asylum appeal the appellant had had. This case is also useful where a judge has cocked up in their determination and said at the end, I allowed the appeal when they meant to dismiss it, or dismissed it at the end when they meant to allow it, and inviting the tribunal to review the decision and set it aside. So if you've got that situation, have a look at that. Just quickly, a big issue at the moment is cessation of refugee status. Emma was in this case along with the head of our immigration team, MS Somalia. That's been followed in SB refugee revocation. And that looks at usually where somebody's been a naughty boy, usually in the Somalian context, they're at risk in their home area. Could they go back? Well, if there's an internal relocation alternative, there can be a cessation of refugee status and somebody could return. It's called the mirror image approach. You get refugee status if there's not a relocation alternative. So if there is a relocation alternative, your refugee status can be ceased. Now some EEA law, and firstly Zambrano. We've touched on Zambrano earlier with the horrible case of Yunus. Zambrano's still a big issue because we know under the settlement scheme we can now obtain settled status with a derivative right of residence. So the Supreme Court in Patel, there are 2 linked appeals. Patel is an Indian national caring for his British parents. Shah is a Pakistani national caring for his British child, but he has a wife who's also here in the UK, British wife who's working. What they do is review the jurisprudence, particularly this case of KA, and they say, have a look at paragraph 22, that what lies at the heart of the Zambrano judgment is the question of compulsion. Would the British citizen be compelled to leave the EU if the third country national is removed because of that relationship of dependency? And they draw a distinction between adults and children. And really, the case of Chavez Vilesh, which concerned children and the best interests of children, doesn't relax the compulsion needed in adults. And adults are only going to succeed in exceptional circumstances. So actually, the Patel appeal failed. So I think in adult Zambrano cases, you're really going to have the exceptional case. In child cases, well, this case succeeded because dad was the primary carer of his son, and the Court of Appeal were wrong to say, well, Mrs. Shah has a choice whether she goes or stays with the child. Because dad had the caring relationship. He was the primary carer, and considering the child's best interest, the compulsion test was met in that case. Chen children can rely on the unlawful income of a parent. Well, that does what it says on the tin. Helpful if you've got some Chen children and you're arguing a derivative right of residence. This overturns previous jurisprudence that went the other way. In terms of Surinder Singh, ZA, really helpful case with Surinder Singh. As you'll know, the Secretary of State has modified Regulation 9 of the EEA regulations over the years to try and make it harder for people to, well, they think just to avoid Appendix FM and go to Dublin for the odd weekend. But what the court has said in ZA, the requirement to have transferred the centre of one's life to the host member state is not a requirement of EU law. When looking at whether residence was genuine, it's about whether somebody intended to exercise treaty rights, and there doesn't have to be integration in the host state. Obviously, work must be genuine and effective, more than marginal and ancillary, which we know is a general test in EU law. In retained rights, Raymond is an excellent case, because I'm sure a number of you have come up with a problem that you've got somebody divorced from his EU national spouse, applying under retained rights, satisfies Regulation 10, but can't produce his ex's passport. This was exactly the case in Raymond, and it was refused only on that basis, even though it was accepted that Regulation 10 was met. There is flexibility within Regulation 42, and in this case, it says that actually some requirements for specified evidence may need to be ignored if it's satisfied that there is a right of residence. And this poor punter had a previous residence card when he was married, so they knew the ex was an EU national, had been exercising treaty rights, and they accepted Regulation 10 was met. Really helpful, actually, some general principles on interpretation of EU law. So if you've got an EU law case, have a look at Raymond, really helpful stuff. Finally then, in the last 7 minutes before we have a sort of 5-minute question time at the end, deportation. We were all excited and hopeful when we had KO Nigeria from the Supreme Court, because KO tells us when making the assessment of unduly harsh, and we know the unduly harsh is exception 2 in 117C, for those sentenced to under 4 years, you only look at the effects on the child or the partner. If it's a partner case, you don't weigh the criminality in the balance. So we thought, ooh, we may succeed in more unduly harsh cases, and they've been allowed by the tribunal. But the Secretary of State has appealed them all the way up to the Court of Appeal, and we've seen these cases being overturned, particularly examples of PG and KF. Let's have a look at PG, because it sets it out very starkly. The wife SAT, and there were 3 children. They acknowledged there would be great stress. They acknowledge lives would be made difficult, but these are the consequences of deportation for any foreign criminal. And many parents of teenage children are confronted with difficulties and upsetting events of one sort or another, and have to face one or more of their children going through a difficult period for one reason or another. And the fact that a parent who's a foreign criminal will no longer be in a position to assist in such circumstances cannot of itself mean that the effects of his deportation are unduly harsh for his partner and or children. And this has been latched upon by the upper tribunal. 2 recent offerings, Patel, just because you've got a British children doesn't mean you're exempt from the unduly harsh requirement, and doesn't mean that alone will mean that dad, say, being deported will result in unduly harsh consequences. There needs to be something more. And again, that was picked up in Imran, that without more, there needs to be something more, just separating parents from children. So if you're preparing a case and arguing unduly harsh, you're going to have to show something more, and make sure you front load your cases, get that good social work report, get the evidence you'll need to show it's beyond the normal distress of deportation. Now, we must remind the Secretary of State and the tribunal that it's not an exceptionality test. There's a different test in terms of those, over 4-year sentence, the very compelling over and above. Unduly harsh is less than that, but it still is a very demanding test. What about the public interest in deportation? Is it fixed or movable? Because often we know that the public interest is very significant against foreign criminals, but in certain cases, the public interest can be reduced, and there is a flexibility in the public interest. Akinyemi, very stark facts, had been born in the United Kingdom in 1983, had lived here lawfully all of his life, never took steps to acquire British nationality, despite being entitled to it for many years. And he had a significant criminality over 4 years, and then significant mental health problems as well. And in this case, the senior president of tribunals says that there is a movable rather than a fixed quality to the public interest. So we must approach the public interest flexibly. Now, don't just rock up to the tribunal and say, well, it's flexible. You can reduce the public interest against my boy. He's a good sort. No, it's got to be showing these exceptional cases, somebody who's been here all of their life and those kind of things. This case also stresses the enduring relevance of the case of Hesham Ali. Just finally then, what about if you're running exception 1 and those who are socially and culturally integrated into the United Kingdom? It's often said, well, if they've been to prison, that breaks their social and cultural integration. It severs the ties. That's not true. And that's not what how a judge should approach it. They should look at or the person's upbringing, education, employment history to see if they're culturally and socially integrated into the United Kingdom. This case is also really useful in reaffirming the Maslow principle in terms of somebody who's been here most of their life lawfully and the strong reasons that are needed to deport someone like that. So that's a whistle-stop tour of some recent case law. I hope that's got you out of your lockdown haze and reminded you of some stuff, but also provided you with some ammunition for your submissions in Article 8 cases, in EEA cases, in deportation, and in asylum cases. Now, what I'm going to do is stop sharing my screen. I'll keep my video on and I'll hand over to Bushra and she'll give us any questions we've got from the chat.
Great, thank you, Adam. Let me just find. Great, so let's get back on. I'm just going to scroll up through the questions and let's go through them.
No, they can't see us.
We can't hear you, Christine.
Oh. Would you mind muting yourselves, please?
Hi, everybody.
I hope I've not upset the clerks. Okay, so let's have a look. So let's just
stop it.
Right, are you likely to be put on the 10-year route if you do not meet the requirements for the rules for the minimum income requirement or the English language requirement? I suppose that's coming from the COVID situation.
Yeah, you will at the moment, unless the Secretary of State has some kind of decision to become a little more liberal about these things. But at the moment, if you don't meet the minimum income requirement or the English requirement, you would go onto the 10-year route. That remains the position. There may be some flexibility about that in due course, but at the moment, it's the 10-year route if you don't meet it.
And I think what we can add, what we said at the seminar earlier today, is that when we're submitting applications online, generally we're tending to find that there's probably about a 6-week gap. So hopefully there's sufficient time to be able to sit the test before then being able to go ahead and book the appointment to enroll biometrics and being able to request further time to do so, which was something that we were saying earlier today also.
Yes.
A representative has received an email from the NHS Home Office email ID confirming that the expiry date does not matter to switch in country. Have you heard anything about this?
I think I probably need a little bit more information. Certainly in terms of switching in country at the moment, if you're talking about switching from, say, a Tier 4 visa to a Tier 2 visa, then yes, the deadline is your leave has to expire before the 31st of May at the moment. That situation may change. But at the moment, switching in country is only if your visa expires up until the 31st of May.
Thank you. When making in-country switches for applications that should otherwise have been made from outside the UK, which form should we use? That's an interesting one. So are we using the application we would have used to apply for entry clearance, or are we applying using an in-country extension application form?
That's a very good question. I've seen no guidance on that point at the moment. I think my instinct would be the extension, but it's not really my area of expertise. You've probably got more idea than me, Bushra, on that one, and making applications, what the right form is to use. It might be a case of you contact the Home Office and you contact the coronavirus help desk and ask them what you should do in those circumstances.
Thank you.
I think
really
that's,
Sorry,
can I just chime in, Bushra? I think Emma's absolutely right. I think it would be an extension, put detailed submissions in, because my worry is that if somebody puts an entry clearance form in an in-country application, it would be just rejected as invalid, and then you're in trouble. So I think that's got to be right. Detailed submissions. Obviously, some solicitors on the call may know better than us, because Emma and I don't submit applications for a living, but certainly that's the inclination.
Sure. Really worrying that the first tier tribunal are triaging cases for oral hearing. This is cost cutting at its best. Could this end up as the new normal even after COVID-19 is over?
I think there's a very real risk of that. I mean, they're trying to push forward the pilot project that they've been running for about the last 12 months in Manchester and Bradford, and having this kind of appellant skeleton argument bundles in advance, bearing in mind that the funding issues have been raised repeatedly as part of that pilot, as I understand it, that they haven't been addressed, and they've just pushed this through. I think, though, the very real difficulty that the tribunal will find is, if you think about your cases, very few of them are suitable to be dealt with without any evidence. And the second you need evidence to prove your case, the second they become unsuitable to be dealt with on the papers, it's going to be maybe cases where you submitted the wrong English language certificate, or there was maybe a little bit of financial evidence missing and your client's satisfied that everything's there. You might in those circumstances say, well, you know what, we'll just do it in the papers, but you've got that option at the moment anyway. Cases where there's a dispute as to whether a relationship's genuine, whether a job's genuine, an asylum claim, whether there's credibility issues, even if there isn't, they're not suitable to be dealt with on the papers. And I think the tribunal may try, but I think they're going to find it very difficult to pursue on paper applications on any kind of large-scale basis.
Thank you. In relation to issued 6-month visit visas, could it be requested for these visas to be extended because they have not been used due to the COVID-19 outbreak?
I don't see why not. I haven't seen any specific policy about visitors, but if you haven't been able to travel and you got a visa for, say, that was valid from the 1st of March, you could certainly ask the question, make representations, and pointing to the ministerial statement, they may turn around and say, well, a visit visa application is very expensive, your circumstances may well have changed, we're not going to just reissue it, but you can certainly ask the question of the Home Office.
Got a comment there. Interesting that it is now possible to provide time slots for hearings. Maybe that is something that we can keep post-lockdown.
Well, possibly not. I mean, they got rid of the 2 o'clock listings in the upper tribunal a while ago, but it would be nice if we could keep them.
What are the options left for a client with a derivative right who was sentenced for over 4 years prior to being granted the derivative right of residence card if they cannot apply for settled status?
That's a good question. So, Bushra, did you say they hadn't yet applied for the derivative residence card?
No, it says so. What are the options left for a client with a derivative right who was sentenced for over 4 years prior to being granted the derivative right of residence card if they cannot apply for settled status?
Well, I suppose they'd have to try and apply under the settlement scheme, and then use the provisions there in respect of deportation to argue they're not a risk and the like. I think that they're in a very difficult situation, apart from, you know, the fact they've got 4-year sentence. So I think have a go, but lower expectations. I think that's a very difficult one with over 4 years.
How do we go about submitting a bundle that's over 50 pages to the first tier tribunal?
Well, that's a very good question. There is provision for the judge to give you permission to apply, to submit a bundle that's more than 50 pages in the directions. I think you've just got to explain why it needs to be more than 50 pages. And if it's relevant, I don't see what they can do other than permit you to rely on the larger bundle.
Yeah, exactly. I think we'll wrap it up there. With those questions. Thank you so much for everyone that was able to join on to the Zoom session. Hope you have found it useful. Thank you to Adam and Emma for 3 identical sessions. You'll be saying it in your sleep now, parrot pattern, I think. Thank you so much. And just a reminder that the recording will be on Adam Pipe's YouTube channel. It will also be on the Bushra Ali Group YouTube channel. And a reminder that number 8 chambers are open for business as usual. If you're requiring assistance with your skeleton arguments, advice or grounds, please feel free to contact the clerks who will be able to put you in touch with counsel that will be able to assist. And please enjoy your bank holiday and stay safe, and hopefully we shall see you all soon. Take care.
Yeah, thanks everyone.
Thank you very much, everyone.